matters arising in arbitration, to issues involving civil procedure, to matters arising out of the United States Criminal Code. It's truly a varied, broad, interesting set of issues. More importantly for most of you, this will be the first time that you'll get to hear actual lawyers argue before a federal appeals court. I hope you'll take the opportunity to absorb all that you can. To the court, its staff, and the lawyers who are here to argue, it's an honor to host you. Thank you.
Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Please be seated. Morning, everybody. Welcome to sitting of the United States Court of Appeals for the Fourth Circuit, or given the venue, the Fourth Circuit in concert. We're pleased to be here this morning, along with my colleagues, Judge Agee and Judge Benjamin. We have 3 cases on for hearing this morning. And we'll begin with 23-1252 OSRX Inc. versus Anderson. Mr. Bach.
Thank you, Your Honors. May it please the court. Appellant's contention in this case is that Gregory Anderson engaged in an 8-month-long campaign to steal its trade secrets. And then in the final 2 months of that, or 2 weeks of that campaign, was aided and abetted by imprimis, his co-defendant. It is our contention that the district court made three primary errors at the lower level. First, it dismissed plaintiff's claims against Imprimis for lack of personal jurisdiction. Second, it dismissed ORX's claims against Anderson and compelled arbitration despite the fact that OSRX is not a signatory to any arbitration clause with Mr. Anderson. And finally, that the district court denied as moot our motion for a preliminary injunction seeking to ensure that Mr. Anderson did not use or disclose our trade secrets in an improper manner.
Can I ask you about that last issue first? And I'm sorry to take you out of order,
Sure.
but why didn't you move to more expeditiously pursue that particular form of relief? And related to that, it's been what, 3+ years since the litigation ensued. So hasn't that ship sailed with respect to preliminary relief?
Your Honor, I would say that first, we moved immediately for a TRO. That was denied. We again moved for a TRO. We moved twice for expedited discovery. The court waited 7 months to conduct a hearing. By the time it conducted a hearing, it ruled on matters that did not involve the preliminary injunction and then failed to consider the preliminary injunction at all. I would say that in the lower court filings, Your Honor, Mr. Anderson represented both in his declarations and to the court that he understood his obligations with regard to the trade secrets, that he had only misappropriated these materials in order to protect his reputation and to prevent, in the case that the plaintiffs began disparaging him. And he represented at the lower court and in his declarations that he would continue to hold these materials until ordered by the court. And so I actually don't think if this court—
How much time passed between the time Mr. Anderson left employment and your suit was initially filed?
I believe it was, he left on May 6th, and I believe we initially filed on June 2nd of 2020.
And you asked for a TRO when you did that?
I believe we filed for that the next day, or it might have been the 7th, Your Honor.
Well, somewhere along the line, if I'm remembering this correctly, the district court found that all of your claims against the defendant fall within the broad scope of the arbitration provision that's in the employment contract. So did you specifically appeal that finding?
As to OSRX, yes, Your Honor, we did. As to ocular science, we did not.
And where would I look in the appendix to find that specifically?
As to the appeal for OSRX, or as to, I'm sorry.
Well, if OSRX is the one that you say appealed that factual finding, where do I find you noting that particular language of appeal?
As to the arbitration clause, Your Honor?
Right. The district court made a finding that all of the claims fell within the broad scope of the arbitration provision.
I apologize. I want to just make sure that I'm answering your question. I believe that our appeal begins in the joint appendix at the beginning of our brief, and I'm sorry, Your Honor, I don't have the specific citation, but I believe it's contained within the substantive portions of our brief. But I think what you're asking me is, where did we appeal the specific language? And I do know in our brief we cite to California law concerning the interpretation of an arbitration clause, and that here the language of the employment agreement speaks to submitting causes to arbitration only those that arise out of or relate to the employment of Mr. Anderson with ocular science, a separate but affiliated entity.
Well, we all know that there's an equitable principle that permits a court to find that a non-signatory who seeks the benefit of those contractual relations to be bound by them. And am I remembering correctly that the suit that was brought, including by the OSRX, included a breach of contract claim?
It did, Your Honor.
All right, so the language of the arbitration provision seems to be fairly broad. All disputes arising out of or relating to my employment or relationship with the company. So it would seem like there's a good argument that your trade secrets and related contentions fall within that language.
I think, Your Honor, under this court's jurisprudence in International Paper Company and its progeny, I think that the court has to look to the factual foundation for every claim that is asserted by the plaintiff. And Your Honor, in American Banker Group, this court reasserted that the court's obligation is to examine the underlying allegation as to each cause of action brought into the contract.
Do you agree that under International Paper that you would be considered an affiliate?
I think yes, Your Honor. I think we would be an affiliate under International Paper. But again, the test that was applied by the district court was not third-party beneficiary or affiliate. The test that was applied by the district court was direct benefits estoppel. Under the direct benefits estoppel test, we look to see whether or not the underlying allegations, whether or not our underlying allegations assert or rely on the contracted issue. With regard to the breach of contract action, I would just like to mention, I think it's important to look specifically at what was alleged. The plaintiffs allege that Mr. Anderson breached his contract by stealing trade secrets, which is a duty that arises independently of the contract and is not dependent on it. The plaintiffs also allege that he breached his contract.
But it would also be a breach of that contract, wouldn't it?
It would, Your Honor. And I think it's very similar to what this court pointed out in R.J. Griffin, which was that when you have, for example, a homeowners association suing on two duties that arise independently of the contract, the fact that they could have also sued for breach of contract does not necessarily mean that the two causes of action that arise independently of the contract are subject to the arbitration agreement.
Well, you might have a stronger case if you hadn't sued for breach of contract, but you did sue for breach of contract, and then you tried to, well, and now you're trying to excise certain claims from the scope of the arbitration clause, which just seems to speak directly to this issue of whether or not your client should be stopped from doing that.
Your Honor, and I understand that, but again, I would say it's important to look at specifically what was alleged in the breach of contract action. The allegation was you stole our trade secrets. Under the South Carolina Trade Secrets Act.
Wouldn't that go to the confidentiality portion of the agreement?
Your Honor, as to the confidentiality portion of the agreement, it is our contention that whether or not you rely on the confidentiality language or look at the trade secrets, information that is defined as confidential in an agreement can also be a trade secret by definition. Here, Your Honors, the allegations that OSRX are bringing is that the theft of trade secrets, our confidential information, was a breach of his contract, but it also gives rise to independent duties and causes of action under the Federal Trade Secrets Act, the Defense of Trade Secrets Act, South Carolina Trade Secrets Act. It could also give rise to causes of action for intentional interference with contractual relations, prospective contractual relations, and the items that we've enunciated in our briefs. And I would also point out that the misappropriation, misuse of the trade secrets is activities that occur after his employment ended. He had the right legally to be in possession of our trade secrets until May 6th of 2022. He did not have the right to use or disclose those trade secrets or to even remain in possession of them after May 6, 2022, when his employment.
But for his employment relationship, though, he would have never been privy to those trade secrets.
That is correct, Your Honor. But again, I would say that his duties, I mean, the South Carolina Arbitration Act 39-830B specifically states that an employee has a duty to keep an employer's trade secrets confidential, independent of any employment relationship or contract. And so those duties, his obligation to keep those trade secrets secret and then not to misuse them to return them, and then not to misuse them after his employment, are independent of any contractual duties that he has. And so these just like in R.J. Griffin, there was a contract that the Homeowners Association was a third-party beneficiary of, and the Homeowners Association could have brought actions under that contract just because it could have. It asserted two causes of action: negligence and breach of implied warranties that arose outside of the contract, and therefore could proceed outside of arbitration. And so, Your Honors, here we would ask the court to allow OSRX to proceed on its claims that do not arise out of or depend on the employment contract in the lower court. Your Honor, if I may, I would like to address the personal jurisdiction issue if there are no more questions on arbitration. There is no allegation here that there is any that there is any arbitration agreement or contract between OSRX, Ocular Science, and Imprimis. Imprimis's motion to dismiss was granted entirely on lack of personal jurisdiction. Neither party contends that an evidentiary hearing was conducted. The appellee's brief speaks entirely to trying to shoehorn the district court's order into a prima facie analysis, even though the district court appears to have applied preponderance of the evidence.
Well, did anybody ever, I read the text entry that says, you've got 20 minutes to argue. Did anybody ever ask for an evidentiary hearing?
Well, Your Honors, we did ask twice for expedited discovery. And so, and that was ignored. That request was ignored until after the motion to dismiss was granted, at which point the court deemed that request moot. Our requested discovery included interrogatories, request for production, and a 30B6 notice to Imprimis that had interrogatories, requests, and seeking testimony on issues and topics directly related to Imprimis's activities, their solicitation with Anderson, their solicitation with our customers, their efforts to induce Anderson to breach his employment contract, and other actions that would have bore on the jurisdictional analysis.
Well, when you were in the hearing, short as it may have been, did you tell the district court you have to, if you don't have an evidentiary hearing, you've got to apply a prima facie standard, not a preponderance of the evidence standard?
I believe that we did assert that the prima facie standard was being used. I don't believe that there was ever any contrary contention that a preponderance of the evidence standard should be applied in this case at the lower court level. And the amount of evidence that the appellant submitted on the jurisdictional analysis was substantial. Imprimis stated in its reply in support of its motion to dismiss at the lower court level that the most glaring flaw of plaintiff's argument is that Anderson does not service SC customers as an agent of Imprimis. This in spite of the fact that on August 15th, 2022, the plaintiffs learned that Anderson had solicited Griffin Eye Center, a South Carolina customer whose primary operations are in Myrtle Beach, South Carolina, which was one of Anderson's accounts when he was an employee of Appellant, a top 5 Southern account in the Southern region, and that we lost this business. That was in Mr. Garner's affidavit, J340-341. That evidence, Your Honors, certainly rebuts the idea that Mr. Anderson, a South Carolina resident and an agent of Imprimis at the time, has directed all of his activities outside of the state of South Carolina.
But your primary argument, I take it, is the district court used the wrong standard.
That's correct, Your Honor.
So if we just assume that we agreed with you, how does that affect the preliminary injunction analysis?
Well, I'd certainly say, Your Honor, with regard to the preliminary injunction analysis, that first, Anderson can be enjoined whether he is those claims are compelled to arbitration or not under Merrill Lynch versus Bradley. But with regard to Imprimis, I would certainly say to the extent that they are in possession of our trade secrets, something that they deny, the court as to grounds 3, 5, and 6 of our requested relief on the TRO, we sought things that they actually in their briefing at the lower court level conceded were appropriate, that they would not misuse or disclose our trade secrets, that they would return our trade secrets to us, that they would account for those things that are in their possession. And with regard to the preliminary injunction, and I see my time's running up, I would just mention, we are currently at the mercy of Anderson. He has said that he is holding this information in case we disparage him. So we are relying on his good judgment, if this case ultimately goes to California, and his definition of disparagement or harm to make sure that he doesn't disclose those things. I don't believe the court requires that. I don't believe the law requires that. And at a minimum, a preliminary injunction should be entered as to that. I see that I'm out of time, Your Honors.
Thank you,
Order
Mr.
the
Bach.
call.
You
Thank
have some time left for rebuttal. Mr. Wesley?
Thank you, Your Honors. May it please the court, Keith Wesley for the Appellees Anderson and Imprimis. And I'd like to thank the Fourth Circuit as well as the College of Charleston for the opportunity to argue here. This case belongs in California. The plaintiff, Ocular Science, is in California. Ocular Science drafted the employment agreement at issue. It put in a California choice of law provision and a California forum selection clause. Ocular Science, as we just heard from my friend on the other side, did not challenge that the claims against Ocular Science are headed to California. So we know this. The corporate defendant here, Imprimis, is based in California. So let's cut to the chase. What's Ocular Science asking us to do? It's asking this court to rule that while the claims against the lone South Carolina resident are going to be arbitrated in California, that there should be a case here on the same
Let me
facts.
ask you a question regarding the standard, because I wasn't clear as to your position. Their position is that there's an error because the judge used the wrong standard to review preponderance of the evidence rather than the prima facie standard. And in reading your briefs, I wasn't clear as if you were conceding that or if you were contesting that.
We are saying that, number one, it's not entirely clear from the district court's order which standard would apply. But what is clear in the district court's order is that the district court held that whichever standard applied, jurisdiction would be denied.
Can you show us where he said that? Because the only reference that I saw was to a preponderance of the evidence standard.
That's at JA 414, Your Honor. And to quote, second line, the record, and indeed the plaintiff's allegations and arguments alone establish only that Imprimis knew of Anderson's prior employment with plaintiffs, and then goes on. So the district court is saying the evidentiary record does not support jurisdiction. The allegations and argument do not support jurisdiction. So either way, Imprimis prevails on the motion. But ultimately, under this court's...
So you think the district court used both standards or used them alternatively?
I'm not sure, Your Honor. It isn't...
Well, if you're not sure, then why shouldn't we send it back to the district court to be sure?
Because the district court made clear in the order that regardless of which standard applied, whether we're looking at the allegations alone or the evidence, that there is no jurisdiction in this case. And there isn't. The preponderance of the evidence standard clearly should apply. This court in Grayson said that, as with many pretrial motions, a court has broad discretion to determine the procedure that it will follow in resolving a 12B2 motion.
Can I ask you, so you say there isn't, but if we assume the allegations of the complaint and what little evidence, the evidence that was presented at the jurisdictional hearing, I don't think anyone disagrees that simply being an employee of a company in a resident state by itself isn't enough to warrant attaching jurisdiction, just as a general principle. But if the allegation is that Mr. Anderson committed tortious acts in South Carolina, and he did so on behalf of his principal, and that seems to be the allegation, why isn't that enough to suffice for personal jurisdiction?
Two reasons, Your Honor. The first is in the cases that the court is describing, in the cases in this area where they find jurisdiction, the theft occurs in the forum state. In other words, the property that is stolen from the plaintiff in the forum state. Here, the plaintiff is in California. The property that Mr. Anderson allegedly stole, and granted, we're in a world of intellectual property here, but the property that was stolen was in California. So Mr. Anderson could have been in Florida. He could have been driving through Alabama. There isn't purposeful availment, even assuming that Imprimis was involved, which according to the district court, he rejected that based on the evidence. So number
Opposing
one,
counsel included in their argument, an example, I don't remember the name of the company that, had been, a client of Ocular and then became a client of Imprimis in South Carolina. And they alleged that, the plaintiff was the one who made that happen. So this just kind of goes back to Judge Diaz's question. Why wouldn't an agency principle be sufficient to engender jurisdiction here?
well, a couple of reasons, Your Honor. The first is that in their opening brief, they said that the agent principal jurisdictional analysis is only relevant when, or can be relevant despite a showing of a lack of purposeful availment. And that's just not the standard. We have to show purposeful availment. And the fact that there's an agent principal relationship is not a loophole that gets them out of the purposeful availment standard.
So would you say that it was incumbent on Ocular Science, OSRX, to present some proof that Imprimis had directed Anderson to purloin certain clients in order for there to be personal jurisdiction?
Absolutely, Your Honor, because otherwise any plaintiff could come in when a former employee is hired by a new company and say, upon information and belief, we see that this our former employee is now in the marketplace. And so they must be conspiring with their new employer. We have no who, what, where, when. We have no details. We have no link in the evidence between any Imprimis personnel and Mr. Anderson. In fact, I would scour the record to try to find a name from somebody at Imprimis who was involved in this conspiracy to use OSRX's trade secrets.
So can I follow up on that? So the who, what, when, where, and why might be relevant if we were dealing with the preponderance of the evidence standard. But if in fact the district court was bound to apply a prima facie standard, then we take the facts and allegations as assumed by the plaintiff to be correct, right? And we don't rely on evidence at that point.
I would say the court is correct, subject to one caveat, and that caveat is Iqbal Twombly. We don't take every allegation as correct. We take well-pleaded allegations as correct. And so a plaintiff cannot come in and simply parrot the legal standards, the legalese, and say, well, we've pled that there's a conspiracy. We've pled that they've aided and abetted, and that's enough. It isn't. You still need some detail to show what is going on, and they just didn't do that, even in their pleadings. And that's what on JA 414, Judge Kane said. It's not just the lack of evidence. It's also the lack of allegations.
So should there have been a burden on Ocular to have requested an evidentiary hearing in this circumstance, or would it have been yours, or neither?
Well, the burden is on the party seeking jurisdiction. And this case, Your Honor, is just like a case from 2018 called Sneha Media. There, like here, the plaintiff, there was no evidentiary hearing, no live witnesses. There, like here, the parties did not submit jurisdictional discovery, but instead submitted affidavits and evidence. There, like here, the parties appeared at a motion hearing and argued the facts and evidence in law. And there, like here, and this is the important part, this court said no party sought to present additional evidence to the court. And what did this court hold in those circumstances? It says, whereas here, the court does not preclude the parties from pursuing jurisdictional discovery and holds a hearing in which the parties may present relevant evidence and legal arguments based on a developed record, plaintiffs will be held to the burden of establishing personal jurisdiction by a preponderance of the evidence. So Judge Kane did exactly what this
Well,
court.
we don't know here unless somebody can point this out in the appendix, whether anybody ever asked for an evidentiary hearing or ever mentioned to the district court, well, maybe we ought to get a little evidence here before we go on, which I think distinguishes this from the case you're discussing.
I'm not aware of anyone asking for additional evidence. The record shows, I read the hearing from the district court level. At no point did the plaintiff say, time out, Your Honor. We really need this deposition in order to prove our point. We really need to talk to imprimis. Give us 20 more minutes and we will prove our point. None of that. And so if they are saying that a preponderance of the evidence standard should not apply, it was incumbent on them to ask for something beyond what the court in SNEA said was adequate for the preponderance standard to apply.
Well, but to be clear, if in fact none of that happened, then I don't think the court should have applied the preponderance of the evidence standard, right? It should have been a prima facie standard if there was no evidence solicited or asked for. If all we've got is the pleadings and some limited information in the record, then at that point, it's not a preponderance of the evidence standard.
I respectfully disagree, Your Honor. Under SNEA media, it says that you do not need live testimony for the preponderance of the evidence standard to apply. Said everything was on affidavits and exhibits and legal briefs. It said all that is required is a fair opportunity to present to the court. So I do not believe that an evidentiary hearing is required under Fourth Circuit case law in order for the preponderance standard to apply.
Well, let's just assume for purposes of argument that we were to disagree with you on the personal jurisdiction issue and agreed with the plaintiffs. What effect does that have on the preliminary injunction determination?
Well, I suppose then the claims against Anderson will be sent to arbitration. As the panel pointed out, it's been 3 or more years since those claims were initially brought. I suppose that Anderson the plaintiffs could then seek injunctive relief in the arbitration if after 3 years they still believe there's an emergency that necessitates it. And I suppose the case against imprimis would go back and the district court would look at alternative grounds for transferring this case to California. In other words, improper or inconvenient venue. And if, again, the plaintiffs believe that after 3 years, there was still an emergency and there was grounds to do it in good faith, they could re-petition the district court for a preliminary injunction. Ultimately, I think we're spending a lot of time here and in the district court, if you were to send any piece back, on procedural machinations that shouldn't matter. Because I believe ultimately what's going to happen, because we have Ocular Science and I believe OSRX going to have to arbitrate in California, the claims against imprimis are either going to get sent to California or going to get stayed pending that arbitration. And so we are spending a lot of time and effort on very interesting legal issues.
Well, believe it or not, sometimes we're all about procedural machinations for better or worse.
I understand.
Let me ask you related to that, and I'm sorry to harp on this. So the district court said several things about the preliminary injunction issue. First, that the issue was moot because the case was going to arbitration. And second, that even if it was not moot, the district court was not inclined to grant relief because there was no carve out in the agreement that would have allowed the court to do that. I don't know that I agree with either one of those because I think the fact that the court transferred the case to arbitration doesn't necessarily make the case moot. The court, in theory, still has jurisdiction over the case. And second, Wasn't there in fact a carve-out provision in the agreement that said that either party could pursue remedies under the California Arbitration Act, which includes the ability to seek a TRO and preliminary injunction relief?
Few responses, Your Honor. First off, standard of review, abuse of discretion. So if, with all due respect, if this panel was.
We're all about that too. That's good. I thank you for pointing that.
If the judges on this panel were sitting in the district court level and would have granted an injunction or would have issued a different opinion, that's not the question here. It's, did the district court abuse its discretion? Now, did the district court know that at least had the discretion to enter an arbitration despite the arbitration provision? I think it did. Here's why. JA 416, district court says in its order that it is declining to do so. In other words, it's not saying I don't have the power to do so. It's saying I am declining granting the injunction, and then explains why, because it thought there was too much delay.
But isn't
That's it.
that what, Aguero, I'm probably gonna pronounce it wrong, says that the district court could not do? Is that similar to what happened in that case?
I'm sorry, Your Honor.
Isn't that similar to what happened in the, I think it's Aguero case, where the district court said that it was improper, I mean, this court said it was improper for the district court to say, just simply say it was moot.
Aguero, it was clear that the district court did not believe it had the legal authority to grant an injunction when there was an arbitration provision. And this court reversed, saying that the district court should have been aware that it had the power to do so. This situation is different in my view. The district court here never said, I don't think I have the power to do it. The district court said, I'm declining to do it. And here's why. So it's not a case of Aguero where the district court is under the false pretense that it doesn't have the legal authority to enjoin. It knew it was going to do so. It knew it had that power and it was declining to do so. And I think there was a second part of your question, Judge Diaz, that I am
There
now
might have been,
forgetting.
but I forgot about it. So move on.
Okay.
Can you talk a little bit about the estoppel issue? Because I just thinking about it, it seems right that, you shouldn't be able to pick and choose your claims and decide which ones are arbitrated and which ones are not. But if the plaintiff in this case had simply rested on its statutory and non-common law claims and not alleged a breach of contract claim, do you think estoppel would be a much more difficult question?
I do. And first off, on the application of estoppel, once again, I don't want to lose sight of the ever important standard of review, which is abuse of discretion. But I do think it would be a more difficult case. This is the easy case. This is where a party comes in and says, you breached a contract that we were a party to, and so pay me money. And we say, okay, there's an arbitration provision in that very contract. Oh, wait a minute. We're not actually a party to that contract. I mean, this is what the Fifth Circuit described as an archetypal example of estoppel. If they had solely brought trade secret claims, didn't reference the contract at all, more difficult case. May still apply, but more difficult. But that's not this case. And unfortunately, sometimes appellate counsel are stuck with the record that they have. And so those are the facts. There's no cutting around it. And I'm not aware of any case, certainly in the papers, any case that we found where a party actually affirmatively sues under a contract that has an arbitration provision and then says, well, I can't be stopped from arbitrating if there's an arbitration provision in that contract. So I have 36 seconds left. If there's any other questions, I'd be happy to answer them.
Thank you very much.
Okay, thank you.
Thank you, Your Honors. Just very briefly in reply, to clear up a couple of points. First, with regard to the evidentiary hearing, my friend, colleague, cited to Sneha several times, but he left out the portion of that opinion where the court specifically noted that prior to conducting the final hearing in this, which it considered an evidentiary hearing, the parties had 2 months opportunity to conduct jurisdictional discovery and were not limited in any way by what they argued or presented to the court. Here we asked twice for the permission, as this court I'm sure is aware, discovery can't begin until Rule 26F conference, and generally does not begin at the lower court level until the parties have been heard on dispositive motions. We asked twice to be able to conduct discovery. That was deemed moot. And this court said in SEC versus Rex that when the district court limits jurisdictional discovery, it should apply a prima facie standard. I
And
think
just in follow-up to, I think Judge Agee's questions earlier, during this hearing where the judge is saying you're gonna have 20 minutes to present your case and you have 5 minutes to respond, is there any objection at any point as to the format of the hearing or as to the standard that he's using?
there were objections, Your Honor, as to various aspects of the way the hearing was conducted and arguments that were raised on reply. The lawyers were very clear in that hearing that they were trying to follow the court's instructions and limit themselves purely to the briefing. But as to the jurisdictional discovery issue, Your Honor, no, there was no specific raising of that at the hearing. I will note that I don't think it's arguable that the district court applied a prima facie standard in light of the record. In fact, the district court made 4 factual findings in favor of lack of jurisdiction. It found that that Anderson does not solicit South Carolina customers, which we had submitted evidence to the contrary, that Anderson was not approached by Imprimis in South Carolina, just instead of assuming as true our allegations that they had and had solicited him and engaged him to steal our trade secrets prior to the end of his employment, instead took Imprimis's allegations as credible, that he doesn't solicit customers currently in South Carolina, doesn't service them there, and that South Carolina only accounts for 1% of Imprimis's revenue, something that we were required to take on Imprimis's word. And given the size of the company, that could be substantial. For example, in Universal Leather, this court found that even $1 million of business in the state of North Carolina could be sufficient to create specific jurisdiction
I
for
believe
claims.
Judge Diaz asked the question earlier, and I want to be sure I understand your answer. And the question was, if we can't tell on the personal jurisdiction issue which standard the district court used, does that mean you prevail, at least as to that issue?
I would certainly say, Your Honor. I would say if we're up here debating whether or not it was preponderance or prima facie, and it certainly appears that my client below submitted evidence which, if taken as true, would create specific jurisdiction, then I do think it has to go back down for clarification on which standard was applied and what evidence was considered from my client's side that the court discredited and did not find sufficient. Finally, Your Honors, and I'll conclude with this as to the preliminary injunction issue. Both state and federal law allow the court to enter a preliminary injunction to protect trade secrets if there is actual or threatened harm. We have Mr. Anderson here essentially admitting in his declaration and pleadings that he is holding this in case he thinks he may need to use it. And in his final, in his filings below, conceded that an injunction, a limited injunction preventing his use, disclosure, misuse of these trade secrets may be appropriate. The claims against Imprimis are not arbitrable. No one has argued that they are. We are not going to arbitration in California. So this case is going to be split regardless.
I'm just curious as to why you didn't file for an injunction in California, because the agreement clearly says that you can.
Your Honor, it does, but again, it also cites to the California provision or the California law, and California statute allows us to move for a preliminary injunction in any court where it would be appropriate to seek an injunction. It does not limit it only to California courts. I see that I'm out of time, Your Honors.
Thank you,
very
Mr.
much.
Rock. Want to thank both counsel for their able arguments this morning. Very much appreciate your being here. We'll come down and greet you and move on to our second case.
All rise.
Connor, good to see you. Judge, good to see you.
Please be seated. All right, our second case is 23-4612, United States versus Booker. Mr. Allman.
Please the court. I'm William Allman from Asheville, North Carolina, member of the CGAA panel, and I represent Mr. Booker on this appeal. Would like to reserve 5 minutes of my time for rebuttal. Mr. Booker represented himself at trial. He then did have appointed counsel for the sentencing hearing. And essentially, there's 3 different sets of charges within his 10-count indictment. Conspiracy to defraud the United States, being count 1, healthcare fraud, violating anti-kickback statutes, money laundering conspiracy, and aid and abet the same. He received a total of 200 months. It's my understanding he's since had a stroke. I was asked to bring that to the court's attention. But in a nutshell, the government contends that he was the mastermind behind a scheme wherein Medicaid eligible individuals were recruited and required to submit urine samples, absent medical necessity at times, in some situations, in order to participate in subsidized housing programs and other programs under the auspices of his company, which was the United Healthcare Services.
Let me ask you
Yes, sir.
to begin. Was the motion for judgment of acquittal done by the defendant pro se, or was that counsel?
I believe the motion for acquittal was alluded to by the court and then made by the defendant at time of trial. He was not, his appointed counsel was not active in the case until the sentencing hearing.
All right.
So,
Because I just looking at that, I'm not sure that there was a challenge in the district court to the sufficiency of the evidence for the anti-kickback statute.
and Your Honor may well be correct on that.
Okay.
I will tell the court that Mr. Booker did testify. He maintained that he was focused on community outreach. His role was different, helping marginalized individuals. He had nothing to do with the administrative responsibilities of his organization, which he had primarily delegated to Mr. Graves, who later pled guilty and was a principal witness against him. And he also had his own lab and he had his own Medicaid billing service. And we do recognize questions of fact and credibility are generally for the jury, but we do contend that there are several issues that do give this court cause to revisit what happened at trial. With respect to the conspiracy charge, as well as the kickback, substantial evidence, again, taken in the light most favorable to the government, does require proof of knowing and intentional conduct. There was no evidence that showed Mr. Booker directly ordered any urine tests, that he procured any standing orders for medical necessity, nor did he submit any bills to Medicaid. All of the billing protocol was done. It was delegated to and administered by Mr. Richard Graves.
Do you think that that's a necessary component of the elements of the offense? I mean, I thought the testimony was that even if he wasn't directly involved, he certainly knew what was going on and approved it and agreed with it.
I'm sorry, Your Honor, I missed the last part of
That's
the
okay.
question.
That even if he didn't directly do those things that you have alleged, that he was certainly aware of what was happening, that his subordinates were actively engaged in this activity, and that he approved of it.
If there was substantial evidence of his knowing intentional participation in conduct.
But wasn't that the testimony at trial?
Well, again, that is a matter that is more properly evaluated, I would say, by the jury, and the jury did make the decisions that they made, but we contend that some of the evidence that they heard, which should not have been heard, and may well have resulted in a different verdict if certain things had not been introduced into evidence, which is part of my argument. I'll jump ahead with the court's approval to
Right, well, but I thought part of your argument is that even notwithstanding those issues, that the evidence just wasn't sufficient.
Yes, sir. We would contend that based on the fact that Mr. Booker's role was quite isolated and insulated from that which was the criminal conduct, that yes, we would contend that there is a substantial evidence argument, which is what we made based on the fact that most of the criminal activity which he was prosecuted for was done by others.
And just so I'm clear about that, your characterization of that role is based exclusively, if not entirely, on your client's testimony, right?
Not entirely, but somewhat, yes, sir. At the same time, the people who were testifying against him, everyone had taken a deal and had reason to say what they said.
That is shocking.
Not shocking at all.
Yeah.
No, sir. I agree with that. But again, I would say that Mr. Graves is the one who, the evidence showed, negotiated the contracts. Ms. Jordan with Legacy Housing had a modified contract that he submitted to the lawyer for approval, Vic Medlin. He is the one who kept track of the referrals. He negotiated the contracts, and the supplemental joint appendix, which the court I'm sure has reviewed, shows that Mr. Booker's signature was on many of the checks, but Mr. Graves had created a signature stamp, and we don't know who actually signed the checks that were in the supplemental joint appendix. It's unclear what information Mr. Booker had at the time he was signing checks, if in fact he was signing the checks. He didn't pay much attention. Ignorance of the law may be no excuse, but it does impact intent. And knowing an intentional conduct is important when you're talking about substantial evidence. Mr. Pear and Ms. Stringfellow of Everlasting Vitality later do it.
So they made about $12
Yes, sir.
million, if I'm remembering this record correctly. He was just the fortunate beneficiary of that largesse.
Was he a beneficiary? Was that your Honor's question?
Right, but I mean, it just.
Oh, he was clearly a beneficiary. I acknowledge that. He owned the company. There was a lot of money going in and out. No question
And
about
wouldn't the
that.
jury be entitled to ask whether he just came by and picked up the checks like he won the lottery, or whether
Well,
that might not be believable?
It was a large organization. United Youth Care Services did a lot of things in the community. They had a lot of programs. They had a lot of employees. So in terms of what was operational, which is also part of my argument, versus what was fraudulent kickback, it's not totally clear in this case. I would submit that.
Wouldn't it be up to the jury? And in this case, he had a trial to determine the criminal intent here?
Well, I have done 30 years of trial work, and I do understand that concept, Your Honor. But we're challenging the idea of knowing and intentional conduct, which is a requirement and an element. And with respect to the jury, I would like to jump ahead to an argument that I really think is what tainted the evidence in this case, and that is the Exhibit 263 of the Sandhills audit. Sandhills oversaw the Department of Health and Human Services operations for United Youth Care Services in particular. And if you look in the supplemental joint appendix, you'll see much of it was redacted. But Section 19 concludes that Mr. Booker subjected clients to exploitation. And that's a key word. That's a loaded word. That's a big word. And we would submit that that was highly prejudicial. So it could well have impacted his credibility and impacted what the jury might otherwise have thought.
But that wasn't submitted in the government's case in chief, right? It was submitted in rebuttal to.
Actually, Your Honor, the exhibit came in the case in chief, I
Okay.
believe, if I'm recalling correctly, it did. And there was a continuing line of objection to that at that time. But you are correct in that the government did double down on that at the time of rebuttal because they offered testimony from the manager, the program manager, program director, actually, of Sandhills. And he further testified that he found evidence of credible fraud, which of course led to the prosecution to begin with. So what we had in this case was we had the results of a civil administrative hearing being utilized in a criminal case. We have a different burden of proof. We had a limited opportunity to cross-examine, or Mr. Booker did. Obviously, he was representing himself. Anyone who was involved in that civil hearing, other than potentially this one program director. So, which is why I cited the confrontation clause
Prior to that,
issue.
Mr. Booker had asked a witness several times. We were audited by Sandhills and they never said anything adverse to us. And that would seem to be opening the door for a rebuttal.
Well, yes, Your Honor, that was the government's contention too in their brief. And he did ask on cross-examination of Richard Graves, were we not audited frequently? And they were audited quite often. And apparently the evidence indicated that it did workshops on fraud and abuse in response to those audits. But then he asked, I believe this was the key, was were we ever told we were doing kickbacks? And that's on the joint appendix to 785, 786. And Graves said no. But I would argue that's a little bit of a stretch to be able to put into into evidence, this type of prejudicial evidence, the exhibit as well as the rebuttal evidence. I think that definitely skews things in a way that was unnecessary to have them skewed, so to speak.
Was there an objection? Was there an objection?
Was there an objection? Yeah, there was an objection, yes, sir, to exhibit 263 at the time. Yes, sir.
Okay.
And that also brings into play the rebuttal evidence with respect to Mr. Booker's bank account. He apparently had a line of credit with United Youth Care Services, and a $1 million debit from that account went into his personal account. And he testified as to that. He was asked about it, and he indicated that he had a line of credit and he was able to maneuver funds back and forth, which speaks to the offense of embezzlement, which he was not charged with. And no bank representative was called to testify with respect to any of that either. And I believe the argument in the government's brief was that shows his intent or his motive to commit fraud or abuse. And that is also prejudicial evidence under 403 we would submit, because it really doesn't show any connection to the charges at hand other than the fact that there was an account in his name that he had access to that also he shared with United Youth Care Services. There's no connection to any of the checks that he wrote out of that account either. So no evidence was offered. Again, no opportunity to cross-examine anyone with respect to that. So that is essentially the argument with respect to the evidentiary concern of the jury function. I think that the jury function certainly is what it is. I can't argue with the way it's been established for years. But when the jury is hearing things that they arguably should not have heard, then that does impact the validity or the taint of the trial itself.
I want to ask you about,
Yes.
while you still have some time, about your merger
Yes.
a portion of the appeal. I'm curious as to what your response is to the government's. The government cites Halstead and says that
Yes.
these two, the reason that they're there's a merger because there's not a merger is because one, that these are two separate actions.
Yes, Your Honor.
Your kickbacks, anti-kickback
Right.
statute.
With respect to money laundering, our argument was that it could arguably be double jeopardy to have him convicted of both the underlying acts as well as the checks themselves. And as far as Halstead goes, cited by the government, that was, of course, a healthcare fraud claim case. But the amounts were broken down clearly in that case. The case I cited, Santos, which was a legal gambling case, money laundering requires a limitation to the net profits of the operation, not including any type of operational expense or
Well,
tax that were
after
written.
Santos, Congress amended the statute so that it specifically includes gross receipts, and that was done several years before the conduct that's alleged in the indictment. So is there anything left of a Santos argument now?
Well, again, I would say that when you're dealing with a situation, Your Honor, that you've got some legitimate activity that is being conducted by an organization that's trying to help the community, and then you have certainly some fraudulent activity going on too. It should be clear as to what is what. I think that was also the result in the Halstead matter. I believe 1.3 million was determined to be fraudulent of the 5.8 million in that case. And in this case, there was no breakdown. So we only have aggregate figures. So a merger of the merger argument being that we can't separate the fraudulent conduct from the other conduct. So
But can you
that will be my
separate-
response as best I can to that.
And you separate it by the type of activity that is the subject of the money laundering. So I know there are cases that suggest that when you're dealing with so-called concealment money laundering, that is different from promotional money laundering, the
Yes, sir.
latter perhaps being subject to merger, the former not. And
Right.
doesn't the evidence in this case suggest that we're dealing with concealment money
Well,
laundering?
and again, we're back to questions of fact, and the concealment has to be shown to be intentional with knowledge. And when you're writing checks, it's pretty easy for checks to be discovered. So I don't know that the act of writing checks in and of itself
What
would
about
be
the
considered.
act of the act of how the checks are written, the 5,000 versus the 10,000, so you don't have to do
Right.
reporting? Would that
Well,
qualify
it could
as
well
concealment?
impact who's responsible for what. Again, they did have a signature stamp, and there's very little evidence as to who wrote what and what was known at the time checks were signed, and who, other than who did it. And we weren't specific with respect to that either, which also goes to my argument with respect to loss amount. If I may, the loss amount determination had no breakdown either, and this was raised by the attorney at the time of sentencing that was appointed. I believe the kickback figure was roughly 1.5 to 3.5 million. And that figure is substantially less than the 9.5 million threshold for a base offense level of 20. I did cite, and I realize it's not binding on this court, US v. Banks out of the Third Circuit, which held that loss should be based on the amount attributable to fraud alone. So again, and as far as sentencing, if I may, I realize my time is running low.
You're
Mr.
actually
Booker,
over time right now.
I'm sorry?
You're actually over your time.
I'm over my time. I apologize. I will simply say 200 months versus 30 months for Richard Graves is a significant disparity. We would submit that the sentence was substantially unreasonable.
Thank you very much.
Thank you.
Mr. Almond. You've got some time left for rebuttal.
Thank you.
Ms. Ray?
May it please the court, Amy Ray for the United States. Your Honors, this court should affirm the judgment of the district court because Mr. Booker received a fair trial and his sentence is both procedurally and substantively reasonable. To respond to Your Honor's question just about the motion for judgment of acquittal, that was something that Judge Bell did himself. He just jumped in and said, I'm going to assume that you filed, we're going to sort of treat this as a motion for judgment of acquittal. That's on page 949 of the joint appendix, if Your Honor wants to refer to that, Judge Agee. Your Honors, the jury heard ample evidence of every element of each of these offenses. With respect to Mr. Booker's intent in particular, Mr. Graves testified about how they learned that kickbacks were illegal. And about 2016 or so, they got education. They learned about the anti-kickback statute. Mr. Pear, Mr. Springfellow, Ms. Jordan all testified that the illegality of the kickbacks was well known. In fact, that is why Mr. Booker had them structure employment agreements after the fact to try to justify those kickbacks. In other words, instead of having a per cup kickback, he crafted false employment contracts with each of these co-conspirators. And maybe one of the best pieces of evidence about that is the fact that both Mr. Stringfellow and Mr. Graves testified about how with the Do It for the Hood program, Mr. Stringfellow would, after he got the kickbacks, he would create an invoice that justified that kickback, even though it was months or, weeks or months later. So proof that that was something that they structured. Dolores Jordan testified about how her payments were structured to avoid any, the payments to her were structured to avoid banking reporting requirements. They were structured to look like payments made pursuant to an employment contract. So there's lots of evidence that Mr. Booker was aware that what he was doing was unlawful and that he had the intent to commit fraud. And that's all that is necessary. And I think that's the only element that he contests. Turning to the question about the merger, the quote, merger problem under Santos, the biggest, there's two responses to that, but the most basic one is you can't have a merger problem in a concealment case, because the idea in a concealment money laundering case is that you are using the financial transactions to conceal the illegality of what you've done. And in this case, the concealment money, first of all, each of those money laundering counts was specifically charged as concealment, not promotion, concealment. And they were the concealment wasn't about the source of the funds, but the nature of those funds. So the argument that the government made was he concealed it by creating these false employment contracts. And then in the checks to Dolores Jordan, which supported each of the money laundering charges, they had a memo line that described the pay period for which she was getting these payments. And so that was the concealment, was the nature of the proceeds. So that fraud that supported the Medicaid funds had already been paid to Mr. Booker. The Medicaid fraud was finished and complete, and then he created this false trail with the checks that referred to a payment period, and that concealment money laundering is a different crime than the Medicaid fraud, and so there's no merger problem. And in this court's decision in Halstead, this court specifically says that if the fraud counts are based on different payments than the money laundering counts, then there's no merger problem. And that was the case here as well. The fraud.
What about in cases after Halstead? I think it's Cloud and Simmons and Abdul, I can't pronounce it, but where they're saying that it's essential expenses to the to the scheme.
Right. And this wasn't an essential, I mean, one could look at it and say, on a broad scale, Judge Benjamin, that these were essential because maybe presumably Dolores Jordan wouldn't have participated if she hadn't ultimately received some money for it. But in terms of it's a whole different act. The concealing, the money laundering concealment is a completely different act. And it can't be that broad. That it's so it's I don't remember, I mean, I litigated Cloud and I don't remember the details of that case, I'm afraid. But in those cases, it was like it wrapped around. And in this case, that Medicaid fraud was done. And it was a different nature. And the 11th Circuit's case in Esquivias, I'm not sure how we pronounce that either, stands for the proposition that concealment money laundering simply cannot merge. It's different conduct.
Can I ask you about you sort of described the activities of different people when you were talking about who did what. And I understood Mr. Alman's argument to be, well, my client was sort of the head of this organization trying to do good, and he didn't really know or understand what the others were doing.
Sure.
And that's why his intent wasn't proven to beyond a reasonable doubt. So what's your response to that?
Your Honor, that's a great argument to make to the jury, and the jury rejected it. And that's my argument. In addition to the fact that all of the evidence, and I can go through joint appendix page numbers where he was aware that the kickbacks were illegal. He specifically told Mark Stringfellow that he could not reimbursement based on cups, that he knew he could not pay them based on urine cups per cup. Instead, he came up with this sort of invoice payment procedure. So there's lots of evidence. At the end of the day, the question is whether a jury could reasonably infer that he had that intent. There is no requirement in the law that the government show direct proof. A defendant does not have to get on the stand and say, I knew, nor do we have to have any particular piece of evidence in which he confesses that he knew. But boy, this case comes as close as any that I've ever handled, in which it was very close. We have that evidence. We have something very close to that. We have Graves, we have Jordan. He and Jordan talked about the illegality. That's what she testifies to. We have Stringfellow and Pear all saying he knew it was illegal. That's plenty.
Can I ask you about the audit evidence? Because I thought
Sure.
that the import of that evidence was primarily in rebuttal, but your colleague on the other side suggested that the exhibit came in even before the need for rebuttal. Is that right?
No, Your Honor, not exactly. So it wasn't during the government's rebuttal case. It was during the rebuttal. It was redirect testimony of Richard Graves. So what happened, and one thing that I did not include in my brief, Joint Appendix pages 768 and 69, the district court warns Mr. Booker, who of course was representing himself, hey, don't open the door to this evidence, because if you do, it's going to come in. And then
So at that point, it had not come in.
It had not. That was before Mr. Graves testified. Mr. Graves testifies on direct. Then on cross-examination, that's when Mr. Booker starts questioning him over and over again. We were audited lots of times, weren't we? Yes. Were we ever told that the kickbacks were illegal? Well, no. Over and over again, he was asked that. And so it was on redirect examination when the government introduced that paragraph. And I would say a couple of things about that, of course. So it is true that it was, and a very easy response, I think, for us is he opened the door to it. It is also true that the confrontation clause is not implicated where it was admitted for a purpose other than the truth of the matter asserted. And in this case, it was admitted as evidence of intent, knowledge, lack of mistake. And I would also argue that even if it hadn't been admitted, the evidence was overwhelming. So any error in its admission would be harmless in any event. The only thing that that finding actually said was really about the provision of substandard housing and how he exploited the fact that he conditioned under Dolores Jones transitional housing programs, the housing subsidy was conditioned on the provision of urine cups. And of course, we had Ms. Hopkins Billings and Ms. Dorothea Johnson, who testified that they had children as young as 5 providing cups of urine for drug testing. And so that paragraph said, yes, he conditioned the housing program on the provision of urine cups for drug testing. But we also had 2 other witnesses that testified to that directly. It would have been harmless. There's no reasonable probability that the jury would have acquitted the defendant had that evidence not been admitted. I will turn, if your honors don't have any other questions about that confrontation clause issue. I guess I'll turn to the sentence. If your honors don't have any other questions about those issues. The district court did not clearly err in finding that at least $9.5 million of loss was reasonably foreseeable to Mr. Booker. The district court heard evidence that about $11.8 million of Medicaid funds went to Mr. Booker's company. And that was through the direct billing of urine for the drug tests. And I want to note that if your honors kind of take a deep dive into this, what we find is that when Medicaid was direct billed for this, those are the tests that we know came directly from Mr. Booker's company and not from the substance abuse providers, because the providers themselves, if somebody actually had a drug addiction problem and they were being seen by his organization for that problem, it was billed indirectly through the service provider. It was billed directly if it was a drug test that came from one of these sort of drug testing mills. So over $11.8 million. That well exceeds the $9.5 million that would support the 20 offense level increase that he received here. This sentence is a downward variance sentence. The district court considered his age, his medical condition. It considered his family. It also considered the difference between his sentence and the sentences that his co-conspirators received. This court has made clear that a defendant who cooperates with the government is not similarly situated, and the unwarranted sentencing disparity challenge doesn't really arise in that kind of situation. But in this case, where we have a presumption of reasonableness that attaches to a within guidelines or below guideline sentence, Mr. Booker has not rebutted that presumption of reasonableness. Your Honors, if there are no further questions, the United States respectfully requests that this court affirm the judgment of the district court.
Thank you very much, Ms.
Thank
Ray.
you.
Mr. Almond?
Just briefly, Your Honor, if I may, I apologize for going over my time. Just very briefly with respect to the factual issues, the government indicated that Mr. Stringfellow would create an invoice after receiving a kickback. That may well be true, but he did not deal with Mr. Booker on that. That was Mr. Graves. Mr. Booker allegedly structured employment agreements. I don't think there's any evidence of that. I think even Ms. Jordan's modified contract was negotiated by Mr. Graves and was referred to the attorney by Mr. Graves. And the Sandhills exhibit, we would argue that's testimonial in nature. And again, as I said earlier, it's a testimonial conclusion on the part of an administrative law judge that the jury gets to hear. So I do, again, take issue with that. I think that would be certainly something that Rule 403 should have excluded. And since our brief was filed, I kind of presumptively included the Loper Bright Industries versus Raimondo case, which was decided, I think, 4 days later. Simply to say that there is a problem with the catch-all, in our opinion, with respect to that statute. It basically gives the Department of Health and Human Services license to decide what is criminal, what is civil, what is right, what is wrong, what is fraud, and what is abuse. Again, this is new ground. I'm not exactly sure how this is going to shake out with respect to a lot of the APA practices, but obviously this court is no longer required to give deference to what they choose to do. And I'm sure your honors are aware of that. You can take a look at this on your own and decide what impact, if any, that may have had with respect to this prosecution, which was instituted, of course, by the Sandhills audit in the beginning. So we would ask respectfully, if there's no other questions, for an order of dismissal, an order of a new trial, or at least an order of a new sentencing hearing.
Thank you, Mr. Almond.
Thank you.
Mr. Almond, you noted at the beginning of your argument that you're court appointed. I want to, on behalf of my colleagues and the entire court, thank you for taking on the appointment. We obviously could not do the work that we do without lawyers who would be willing to represent clients on a court-appointed basis, and we're grateful to you for your able argument here today. Ms. Ray, as always grateful to see you and appreciate your argument on behalf of the government. We'll come down and greet the two of you and then move on to our final case.
Thank you.
To see you.
Thank you. Always. Thank you.
Please be seated. Our third and final case is 24-1395, Bryce versus Independent Bank. Mr. Wessler, whenever you're ready.
Thank you, Your Honor. May it please the court, Matthew Wessler for Jamila Bryce. With the court's permission, I'd like to reserve 3 minutes for rebuttal. The district court in this case held that South Carolina's door closing statute, section 15.5.150, categorically excludes out-of-state class members from participating in a proposed class action in federal court. And on that basis alone, it refused to certify the class. That conclusion is wrong for 3 reasons. First, it directly conflicts with the explicit construction that the South Carolina Supreme Court gave to this statute in Farmer versus Monsanto, which is that section 15.5.150 by its terms, and I'm quoting here, applies only to actions brought in South Carolina state courts and clearly does not apply to federal suits. That interpretation.
If we agreed with you on that particular argument, then we need not go any farther.
That's exactly right, Your Honor. And that's because there's a fundamental federalism principle at play in this case, which is that if a state rule does not apply in federal court, there is no conflict, and the federal court would not perform any Shady Grove analysis, or for that matter, undertake a murky Erie analysis about the potential relationship between the interests at play. I think that—
Can I ask you about that? So, and obviously with great respect for the South Carolina Supreme Court, but why would the South Carolina Supreme Court get to dictate to a federal court how it would apply or not a state statute?
Sure. So I think with respect, Your Honor, that asks the wrong question. What the South Carolina Supreme Court was doing in Farmer was not attempting to dictate to a federal court how to apply any kind of Erie analysis. Indeed, in Farmer itself, the question was not a question about federal versus state forum, or even for that matter, about the conflict between federal or state law. All the South Carolina Supreme Court was attempting to do in Farmer was to supply a interpretation of its own state statute. And that is an antecedent question to the question about what a federal court is required to do when undertaking a conflict analysis between state
But
rules.
is that a interpretation of the substance of the law or the procedural way in which it's going to be applied depending on the parties and where you happen to be litigating?
Again, I think this is neither. I would suggest it's not either a substantive or procedural gloss on the statute. All it is the South Carolina Supreme Court construing the terms of the statute. Now, if I understand your question, the statute itself, section 15.5.150, is a procedural South Carolina statute.
Right.
And so the South Carolina Supreme Court was construing how that procedure applies. But when it comes to an Erie question, let's say.
But it was construing it in the context of a state class action, right? Not a federal one. It was responding to an argument by a party that suggested what the results should be based on one of our decisions.
Yes.
And that's fine. That they're certainly entitled to do that. But I'm still wondering why we would be bound by that result. I mean, we might end up there for different reasons.
Yep. Well, I think you're bound by it because it reflects the state Supreme Court's substantive, to use your word, interpretation of the provision. And this court has said on multiple occasions, we as federal courts are bound to accept a state Supreme Court's interpretation of its own statutes. It is as if a state Supreme Court were to construe the statute, it is as if that construction was put into the statute, no different from if the legislature had amended it.
Yeah, I don't disagree with that principle of law. I just wonder about the application in this context when the question is, who gets to decide and what are the rules of the road with respect to those decisions?
Well, I think there's no question that the federal court gets to decide the conflict question, but the federal court, as it comes to a federal court in this context, for instance, assesses that question based on the meaning of the state law as that meaning has been fixed by the state Supreme Court. And
what if the South Carolina Supreme Court had said this rule actually binds a federal court?
Sure. So, I mean, I think that would be a very different situation, and a federal court would not be forced to adhere to a state Supreme Court's attempt to deprive that federal court of a kind of eerie balancing. But that isn't what the South Carolina Supreme Court did. In fact, it actually did the opposite, because it said the way that the federal courts have been interpreting this statute is incorrect. As a matter of state law, it only applies in state court.
Right. It's doing the eerie balancing for us, but I'd like to try to do it myself, I guess is the point.
Yeah, except it's not, I would just respectfully push back on the idea that what is going on is an attempt to perform the eerie balancing itself. I think, if for instance, this court were to look at, the Supreme Court's decisions on what federal and what a state court can do in the eerie context, what it has said is a state court can't label a state rule procedural so as to escape the way a federal court would perform an eerie balancing test. That we would suggest is entirely correct. But what we're talking about here is a threshold question about what the meaning of this state statute is, and what the South Carolina Supreme Court has said
And
is.
the argument is that the statement by the South Carolina Supreme Court is dicta. I know you're arguing that it is an authoritative decision by the court,
Sure.
but tell me why it's not dicta.
Sure. So, I mean, it's not dicta for several reasons. First and foremost, it's the only reason that the South Carolina Supreme Court gave for rejecting an argument that one party had made in that case, which is that it was bound to follow this court's older Fourth Circuit cases interpreting the statute to apply in federal court. But also dicta, is the kind of thing this court has said is comes up in the context of a decision where it's cursory, or it's a throwaway sentence or line. And here I think you have the South Carolina Supreme Court not doing this in any kind of offhanded way, but explicitly taking up the question of what does this statute mean and supplying an unambiguous answer to that question. Now, I guess, Judge Benjamin, I will say, in our view, it doesn't even really matter whether you treat it as binding holding of the South Carolina Supreme Court or as dicta, because ultimately what this court is required to do under, again, basic federalism principles is ask what the state Supreme Court would understand this state law or state rule to mean. And here you have an unambiguous answer to that question, which is that the South Carolina Supreme Court has said this statute doesn't apply in federal court. It only applies in state courts. And because regardless of the exact context in which that came up, this court ought to understand that that is the considered view of the state court. And as a consequence to that, as Judge Agee, you suggested at the beginning, there simply is no conflict between that state rule and anything that's happening in this case, because we are in federal court. And so it just a fortiori doesn't apply here. I think, independent, in response beyond pushing aside to this question of, whether or not the state rule applies in federal court, has also asked this court to accept what I think is a basic category or about the way in which a federal court would actually perform the conflict analysis, even in the event that this state statute would actually apply. And what it says is, the district court here was correct to undertake an eerie analysis. But I think that really misses the core aspect of the conflict here, which is that we're not in a world in which a federal court is being asked to compare a state rule and a judge-made federal rule. What we're talking about is a state statute that involves a question of capacity and federal rules of civil procedure, Rule 23, Rule 17. And in that situation, the Supreme Court in Shady Grove made very clear that a federal court doesn't actually have to get into the kind of murkiness of eerie. And instead, it simply asks, does the federal rule control the question at issue? And if so, it doesn't really matter what the state rule does, the federal rule has to control.
So, and I'm glad you got there, because I think that's at least where I'm a little bit more comfortable dealing with this issue. And with respect to the Supreme Court of South Carolina, I think we do defer to the issue of what the statute means in terms of capacity versus jurisdiction. And I think they said very clearly in Farmer that this is a statute that deals with capacity, not jurisdiction. And so we accept that. And then we look to the relevant rules in the federal sphere. We have Rule 17 and then Rule 23. And in your view, those rules answer the question. Right?
That's right, Your Honor. You don't actually have to go any further than that to ask, as the district court did here, what are how do I balance the countervailing interests between the federal rule or the state rule? That analysis, as I think both this court in Pledger and the U.S. Supreme Court in Shady Grove made clear, simply doesn't apply when you're dealing with federal rules of civil procedure. It might, if you're talking about judge-made rules that are, not enacted by Congress or, are just kind of developed as a matter of common law. But in a federalist system where we both, Rule 17, both squarely control the key question at issue in this case. And once you get to that point, as this court in Pledger made clear, that's the end of the inquiry.
But there's the argument that, and I think the argument they're making is that there is no conflict because the rule, because the state statute deals with the scope of class actions while Rule 23 does not.
Yes, that's correct. I think, in Pledger, this court took up a similar kind of question. The U.S. Supreme Court had a similar kind of argument it confronted in Shady Grove, where the other side came in and said, look, it's not exactly the same. It doesn't exactly cover precisely in the same way that Rule 23 does. In Pledger, it was a question about what was required to satisfactorily plead a claim. In both cases, what the court said was, this is a functional analysis. It doesn't require splitting hairs finally about exactly the way in which the rule might be structured or the precise language that the rule is composed with. What matters is, does it functionally affect the same inquiry? And here you've got, I think, an undeniable conflict because under Rule 23, there is no capacity limitation in the way that 15.5.150 works. This case would be allowed to move forward under a straightforward analysis of Rule 23, but because of this door closing statute, applying it in federal court means it cannot. And that's a square functional conflict in exactly the way that that Shady Grove expects the inquiry to function, and the district court, by refusing to acknowledge that or perform that analysis, I think ran afoul of both Shady Grove and this court's decision in Pledger.
Let me ask you a question about there's an argument that to the extent that Rule 23 can survive in different contexts, not necessarily maybe in South Carolina, but perhaps in other jurisdictions, that it really isn't a problem, a conflict, because in theory you could have class actions that don't include South Carolina residents. So is that a legitimate argument?
I don't think so. Again, I think what the Supreme Court in Shady Grove made clear is that these federal rules are expected to have uniform application in federal court throughout the country. That's the entire purpose of a uniform set of rules. And so to have a kind of waxing and waning of the ability to bring the same case in federal court, depending on what state you're in, is inconsistent with the way that the rules are expected to function. Unless the court has any further questions, I'll reserve the rest of my time for rebuttal.
All right, thank you very much.
Morning, Your Honors.
Nicely. Mr. Nicely?
Yes, sir.
Go ahead.
Jonathan Nicely at Nelson Mullins on behalf of the defendant, Appellee Independent Bank. And I'd be happy to start with the farmer analysis as this court started. It's actually kind of step 2 of the analysis, because I agree with my co-counsel. The first question when you're dealing with a potential conflict between a rule and a state law is, does the rule govern, or can they coexist? And then if you determine that they can coexist, then you go to the Erie analysis to determine whether that state law applies. But because we have that statement from the state Supreme Court, I understand why my co-counsel start there, so I will start there as well. And I will say that that cannot bind this federal court. It is the federal court's job.
The state Supreme Court says what the law of that state means. So if it says this is what the law means, I don't see under federalism how that conflicts with the federal court. It hasn't made a substantive decision. It hasn't made a procedural decision. It says the law means this. And if that's the case, we're done.
Your Honor, I would respectfully disagree that that is what the court was saying in Farmer. They're not saying what the law means. They're saying, does it apply in a federal form or not? And that is an Erie analysis. That is the federal court's job to conduct an Erie analysis.
But
I think
why
I
would
called
it
it,
need to do that? I mean, the Supreme Court says this is a state statute. The statute can only apply in state court, period. How do you get to Erie from that?
so back in Guaranteed Trust, the Supreme Court of the United States said whether the state describes its laws is as substantive or procedural is not definitive, right? That doesn't define our Erie analysis. We have to look past the way they're described and look at what the law is and what it
So under
does.
your theory, there would be no circumstance where a state Supreme Court could say what the law means, regardless of the context, because there would always be an area analysis.
They can say what the law means. And I think Judge Diaz kind of parsed out that distinction. It means that it governs capacity. But what it doesn't mean, they can't define whether or not it applies in federal court. In fact, the Fourth Circuit has applied it in federal court. So they would, it would effectively overrule Fourth Circuit precedent as well. I think really in a judgment.
Right, but we're bound when we're dealing with state law to follow the state Supreme Court, not our own decisions that are contrary to the state Supreme Court.
Right. And I do want to point out what Judge Benjamin asked about as well, that this is pure dicta. I mean, this had nothing to do with the result in that case. There would be no occasion where a state Supreme Court would have to opine on what would apply in federal court. So it is dicta. It's not the law of the state binding on this court, to your question, Judge Agee. But I want to.
So what difference does that make? If the Supreme Court of a state says this is the law, does it really make a difference whether it might be dicta in that case?
Yes, and I want to go back to the point, they cannot define what the law of this court applies. And I want to kind of drive home what this would create in the Erie analysis, the Erie question that federal courts decide every day. You wouldn't just have to say, is it substantive? Is it procedural? What law applies? You would have to ask the question, would the state Supreme Court say that this applies in federal court? What would they say about whether or not this applies?
Well,
I describe that
that's
as
a different question. If it said, yeah, it applies in federal court, well, then you do have a federal jurisdictional issue. But if the state court says a state law only applies in state court, I'm still not seeing the nexus to Erie.
because it would eviscerate the Erie analysis. When we determine what law this court applies, you apply Erie, the Rules of Decision Act, the Rules Enabling Act. You apply federal law to determine
Right, but
what law applies.
that's when there's a conflict.
What-
What's the conflict here?
Okay, good question. So that's, the conflict is who has capacity to sue. Well, I don't know if Erie applies whether or not there's a conflict. Erie is what substantive law is going to apply to the case. I think irregardless of the conflict. That is what law applies to the causes of action. You get to Erie after an analysis of whether there's a conflict between a federal rule and a state statute, which
So
is.
can I ask, let me describe an example and see if this might help, because Judge Agee's point is well taken, but I mean, if this were not a class action, it was simply a diversity action involving parties that would otherwise not be allowed to sue in South Carolina because of the door closing statute. It seems odd that we would say, well, South Carolina has said the door closing statute doesn't apply, a different result in federal court simply because you happen to be in that venue. That doesn't seem to make sense to me.
That's right, Judge Diaz. I would agree that does not make sense. And in fact, I will say below, the plaintiff never raised this argument. They acknowledged that the door closing statute would apply, absent the class action circumstance. They only raised the farmer issue in the objections to the magistrate's report and recommendation. So there was never even an issue in this case until very late, despite multiple levels of briefing. And that's the question of, whether the door closing statute would apply in an individual suit. So,
Well, let's assume that I'm not clear exactly where we're going to end up on that issue, but let's assume we get past that and we get to the issue of a conflict. You've got a problem there, I think, but maybe you can tell us why you don't.
I hope I don't have a problem, Your Honor. So under Shady Grove, we asked whether the federal rule answers the question in dispute. And I think Ms. Bryce, they want to frame the question much broader than it is. They want to frame the question as whether Rule 23 permits a nationwide class action. That's not the question in dispute in my mind. The question in dispute is whether unnamed class members must satisfy capacity requirement under state
But
law.
isn't that the question, who has the right to sue? Wouldn't that go under Rule 23?
Well, I would say who has the right to sue is Rule 17, and
The
Rule 17 directs you to state law. So it kind of gets you back to South Carolina law, the law of the forum, or the law of the resident of the plaintiff in some circumstances.
So how would
So-
you differentiate this case from the New York statute in Shady Grove?
I think it's very easy to differentiate, Judge Agee. So in Shady Grove, the lower courts, they didn't conduct a Rule 23 analysis. There was no, is there numerosity, commonality, typicality? They looked at the state statute and said, this statute forbids class actions. So Rule 23 need not apply. In our case here, Rule 23 was applied. The lower courts applied the numerosity legal analysis, and the magistrate judge specifically found that Ms. Christ's attempt to establish numerosity is thwarted by the door closing statute. Rule 23 applied. And they can coexist. The question you ask is, does the scope of the rule, is it sufficiently broad to cause a direct collision with the state law or implicitly control the issue before the court? And Rule 23, my co-counsel or my colleague made a comment about how there's no capacity limitation under Rule 23. I'm not really sure where that came from or what authority that is from. I don't know why there wouldn't be a capacity limitation under Rule 23. There's no indication that Rule 17 and Rule 23 don't coexist. I would proffer there is a capacity limitation in Rule 23. And because of that, you have to apply the state law for capacity under the door closing statute. So these two things easily coexist. It's not whether the class can be nationwide or not. It's whether it's the scope of the class. Who can satisfy the requirements under state law to state a claim, right? It's no different than a state statute of limitations. Rule 23 doesn't discuss statute of limitations, but clearly the scope of the class must be limited based on who can satisfy the state law underlying the claim. Rule 23 doesn't discuss conflicts of laws, but we know all the time we have class actions that break out claims by state, right? Because you can't assert a breach of express warranty class action under South Carolina law nationwide, irrespective of the door closing statute. It has to be limited. The scope of the class is always limited by application of state law.
Well, now you've got me a little bit confused. Let me go back to the beginning. So neither, as I understand it, neither Rule 17 nor Rule 23 require capacity to sue in federal court.
No.
You disagree with that?
I do disagree. Rule 17 does require
For absent class
capacity.
members.
Rule 17 says in all other circumstances, capacity is determined by the law of the forum.
Tell me where it talks about absent class members.
It does not specifically address absent class members, but it has a residual provision in all other circumstances. I don't know if it exactly says that, but it's in every other case, right? For all other parties, I think is how it describes it. And a couple of years ago, the Supreme Court took up the question of, do absent class members have to have standing? And they said, yes, they do have to have standing. No different here. Rule 17, all other parties, capacity is determined by the law of the forum, which, this wasn't specifically addressed by the parties in the briefs, but, Rule 17 then directs you to apply the door closing statute. There's no conflict. You're directed to apply the law of the forum in that circumstance. So yeah, and I apologize if I got you confused, Judge Agee. It's my overall point is Rule 23 and the door closing statute can easily coexist.
I'm very happy to be Judge Agee, but I'm not.
Yes, I apologize. And I want to also say, so even if the court does find there is a conflict between Rule 23 and the door closing statute, that is not the end of the analysis. You then go on to the second step of Shady Grove, and you ask, does the rule abridge, enlarge, or modify a substantive right? And here it would both enlarge non-resident plaintiffs' abilities to be members of a class in South Carolina, and it would abridge independence right as a foreign entity to not be subject to suit by out-of-state to things that are not connected to the state of South Carolina. I want to briefly, I guess, discuss this court's precedents and also how this District of South Carolina.
Do you have a case that actually says that Rule 17B applies to representative to class members who are not representative parties?
I have not seen a case either way, just
Okay.
yes.
So that's just your read of the statute.
Yeah, I mean, it's the way Rule 17 is written, it says all other parties. So if it's all, then it would apply to absent class members as well. I think the case law indicates that absent class members are not necessarily parties before a class is certified, but they do become parties once a class is certified. So they therefore cannot become a party if they do not have capacity to sue. And like I said, I think it's very similar to the standing analysis that the Supreme Court recently decided a couple of years ago. Yeah, the historical listing statute has been consistently applied by both the Fourth Circuit and the district courts within South Carolina for decades. And the Supreme Court's kind of, I call it throwaway language, just an offhand comment about its application in federal courts should not change or upset that clear precedent of both this court and how the District of South Carolina has applied that law. And if there's no further questions, I'll rest on my briefs.
All right. Thank you very much.
Thank you.
Just a few brief points in rebuttal. Judge Diaz, you just asked whether my friend on the other side had any case suggesting that Rule 17's capacity rules have ever been applied to absent class members, and the answer is no. That's never been, there's not a single case anywhere that has ever done that. Rule 23 itself, Judge Benjamin, does include a specific reference to the scope of a class. That's in Rule 23 C1 3. It actually asks the district court as part of its process to identify the class members. This court's decision in Pledger, I think, really illustrates the framework, assuming this court were to bypass what the South Carolina Supreme Court has said about the statute, the way that this works. In that case, the government, who was attempting to impose an additional requirement on the rules of federal procedure based on state law, said there is no conflict between the federal rules and the state statute because you can just do an additional thing when you're pleading a claim. This court in Pledger said no, that the introduction of an additional requirement that isn't required by the federal rules is in itself a conflict. I also think Pledger is useful for the basic principle that the reason the court identified a conflict in the first place between state law and the federal rules was, as the court said, because, quote, by its terms, the state rule applied in federal court. I would submit here that by its terms, 15-5-150 does not apply in federal court, and this court need go no further than that to resolve this case.
Look, let me ask you again about capacity in Rule 17.
Yep.
So do you think that does Rule 17 have anything to say about this case?
No, well, we don't think it does, to the extent that, because we think that there is no conflict at all, to the extent that one wants to think about whether there's a conflict between the state's capacity rules and the federal rules capacity rule. That in and of itself is a conflict because, in fact, it is not the catch-all provision that Independent has suggested would even control in this case. That catch-all provision 17B3 refers only to partnerships or entities. There is a different capacity provision 17B1 that refers to individuals, which is the only kind of entity we're talking about here, absent class members, they're people. That capacity provision does not adopt the rule that applies in South Carolina state court. It focuses on domicile, not residency. So there is a difference there. But our position, most, I think, fundamentally, is that there is a conflict between Rule 23 and what is going on with South Carolina's door closing statute. And for that reason, it's Rule 23 that must control.
All right, thank you very much. I want to thank both counsel for their arguments here this morning. We're going to come down and greet you. Then we're going to recess the court and conference the cases. And then we'll come back and answer questions from the audience and or one of the faculty members. So if you would, Madam Clerk.
This honorable court stands adjourned. Sonny Die, God save the United States and this honorable court.
Pen?